Well, good morning, everyone, and thank you for your patience as we're getting started this morning here in Minneapolis. Um, Today, we are merging the Symposium for the Minnesota Journal of International Law and our special undergraduate class that we have here at the Law School on Law, Business, and Human Rights. So we have a good group here in person, and we're joined also by guests and participants online, we hope. And my name is Amanda Lyons. I'm the executive director of the Human Rights Center here at the law school, and I'm really excited to be here with you all today. We have for quite some time now shied away from doing hybrid events, in part because it's always so complicated, but I promise you that today it is worth the stress of trying to connect remotely because we're joined by two really exceptional experts. And so a conversation that would not be possible if it were not for all the technology and all the hard work and sweat from our friend Randy up in the tech booth. So really grateful for that. Students, hopefully you got your attendance form. I'll take that down, but I do not push anything to get out of the slide, but I'm ready. That's all we needed for the attendance. The symposium that we're having here at the law school today is really a series of conversations with distinguished experts across different areas of specialty and expertise, all talking about how international law and international legal experts and advocates are trying to account for gender-based crimes in international law. So different efforts that have advanced or not in trying to capture different kinds of harms that affect women and girls disproportionately. And today, in connection with our class, we're going to be hearing from two experts, one from the Ukraine and the other from Palestine, on these themes, and especially with a lens to accountability for corporate actors. By way of brief introduction to the class that is here today, this is a unique multidisciplinary undergraduate course that we offer here at the law school that's supported by the Human Rights Center. In this class, we have 70 really exceptional undergraduate students enrolled. So it's about a quarter students from the Carlson School, the business school here at the University of Minnesota. About half are from the different programs in the College of Liberal Arts. And the other quarter is a great mix of, I'm sure I'll miss folks. We've got design students, engineering, public health, education. And so it's really a great class with people bringing in different areas of expertise to look at these questions about corporate accountability for human rights violations and harms. We've in our course kind of gone over 4 different sections. We're in the last section of our course. We've talked about the origins of this field and thinking about how corporate actors are involved in human rights violations. We've looked at the challenge of accounting for the role of private actors in public international law, and then specifically in the international human rights legal system. And now we're in a section of our course where we're looking at real world accountability efforts, the challenges for those, and kind of the new frontiers and new initiatives. And so it's in that context today that we get to hear from our guest experts. I'll offer just a very brief introduction and then ask our 2 experts to introduce themselves a little bit more, tell you a little bit more about the work that they do. So first, we're joined by Ina Linyova, who is joining us from Ukraine. She's a Ukrainian lawyer, but we count her as part of our Minnesota human rights community. She lives now here in Minneapolis. She has a special expertise in transitional justice, human rights, the rule of law. She's the director of the Human Rights Institute at the Ukrainian Bar Association, and she's held several different roles that kind of come together to give her this great expertise. She's managed several different kinds of projects in justice sector reform in Ukraine, sponsored by international development. So we'll be looking forward to hearing from her. And then Lina Fatum, who's a Palestinian human rights lawyer. She got her education here in the United States at the University of Virginia and her law degree at George Washington. She also brings a wealth of expertise in both private and public international law and corporate litigation. She sits on the board of Paltal, which is the Palestinian telecommunications company, and directs several projects there. And she's worked with several prominent human rights organizations, including Amnesty International and Al-Haq. And so we are in for a treat to hear the perspectives and insights from our experts, and maybe I'll ask both of you if it's easy to come off mute, and maybe Ina, if you could go first. Would you mind saying just a little bit more about yourself and the perspective that you bring before we get into the presentations?
Thank you, Amanda. Hello, everyone. Thank you for the invitation to join. Well, first of all, for organizing this very timely and very relevant discussion, which unfortunately concerns more than one country now. I am very happy to join the event and share our perspective on what we do. In addition to, well, I probably should add that in addition to what Amanda mentioned, that in 2022, when the full-fledged war against Ukraine began, I was the executive director of the Ukrainian Bar Association, and we sharply prioritized opposing the aggression against Ukraine by legal means. So since 2022, we focus, among other things, on supporting national legal community, national system of justice in processing various international crimes that are being committed in and against Ukraine, as well as advocating and supporting international mechanisms of accountability, which do have gaps, and that's our focus of expertise. So we do a lot of we implement a lot of initiatives at the national level, international level, and we believe that the international system of accountability for international crimes should be maybe redefined. It's time for the next leap in the evolution of the system, and we believe that the war in Ukraine, as well as in the events in Palestine, are a big proof of this. I'm happy to have this discussion and share any information that might be relevant to you. I also think that talking to students, to the next generation of legal practitioners, is of utmost importance, because ultimately you will be the people who will shape the justice system, and will it will depend on you how international and national systems of accountability will function. So I hope this will be a very interesting discussion, and also I'm very much looking forward to hearing to Lena and see if we have common points and common issues to work with, and maybe we can exchange some good practices.
Great. Thanks so much, Ina. We'll come right back to you, but I'd like to hand it over to you, Lena, if you wouldn't mind just introducing yourself a little bit more about your background and work before we get started.
Sure. So hello, everyone. My name is Lena, and as you've heard a little bit about my background, I am a US trained lawyer. I've worked in both private and public law. I've focused quite a bit of my career in the past on corporate litigation for human rights abuses. And I have to tell you that it's a really frustrating field to be part of, to be quite honest, because for every step we go forward, we always go many more back as well. As the international legal system is based quite a bit on reciprocity and the need for states to want to actually have an international legal order, it puts us in a position where we're constantly discussing things with state leaders. And when I say states, of course, I don't mean US states, I mean countries, international states, about nation states, about their political will and why there is a need for international law and international order, and accountability is the linchpin of that whole system. And without it, we end up losing quite a bit of what has been gained over the past 70 years since the system's been really moving forward. A lot of my work, like I said, has been with human rights organizations, but much of it is also with humanitarian organizations. And there we see the way in which IHL, International Humanitarian Law, or international human rights law, impact people in their daily lives in situations of conflict. And even though we know that accountability mechanisms often don't meet the standards we'd like to see, they're still important tools for us as lawyers to help push back against harm to civilians. And I just want to stress this point that as frustrating as things can be, there's a lot that we can do if we can move the political will towards it. And I think I agree with a lot of what Ina has already discussed. And you are coming to a point now where international law itself is in question. Do we still have this international legal order? Is this something that will continue going forward? And it's up to lawyers in each of these countries, in each of these states, to really push forward these thoughts with their governments, with the kind of laws that you institute internally, and the way in which these accountability mechanisms can go forward. And particularly when we have international actors like corporations that are no longer just states and no longer individuals alone, this becomes even more important. So I guess what I'm trying to say is that in my CV, I don't list everything I've worked on, but I have brought a number of cases or worked on a number of cases in international courts and in state courts in Europe in particular to try to bring accountability to some of the most grave violations of human rights. And unfortunately, it is really the laws of each state that make the difference, and the way in which there is a political will of people who live in those states to push these forward. And I hope that today you'll understand that a little bit more and help us to maybe think about how we can increase the accountability through those mechanisms as well. That's it. Thank you.
Thanks, Lena. And I really do think that sets the conversation up really perfectly for us and a lot of the questions that are coming up from our students and our colleagues, honestly. So looking forward to hearing your reflections on that. So maybe let's turn it over to Ina now for kind of more opening remarks on your perspective before we turn to Lena, and then we'll take some questions. So over to you, Ina.
Thank you so much. I will go briefly through the conflict-related sexual violence, which is the main issue within the wider framework of a gender-based violence and also corporate accountability. And I will be very happy to answer your question. My internet is not very good, so I'm not going to use the presentation, but I can share it with Professor Lyons if it might be interesting for someone. So when you talk about conflict-related sexual violence, unfortunately, it's one of the gravest systemic issues that we see in the context of the war in Ukraine. I should start with saying that this crime is recognized and well documented by various international institutions. The UN Commission on Inquiry in its report affirmed that conflict-related sexual violence has been used as a method of warfare, including in various settings, among other things, detention, occupation, as well as other situations. The recently adopted judgment of the European Court of Human Rights in the case of Ukraine and the Netherlands versus Russia, which is the first big interstate case that laid the foundation for future international proceedings. And this judgment is of great importance for accountability. It says that, and this is the quote that I wanted, the only quote I'm going to share with you, is that the court is persuaded that sexual violence and rape was deployed in Ukraine following the February 2022 invasion as part of a military strategy to dehumanize, humiliate, and break the morale of the Ukrainian population as individuals and as a community, and to assert dominance of the Ukrainian sovereign territory. Thus, the court recognized that rape has a systemic nature and is being used as a method of war. In the beginning of 2026, the Ukrainian law enforcement authorities documented and initiated criminal proceedings in 400 432 cases of conflict-related sexual violence since the start of the full-scale invasion in 2022. These crimes were also committed since 2014 when the territories of Crimea and Eastern territories were occupied but for statistics purposes, it's a little bit confusing, but we have numbers since 2022 separately. So only 432 cases, and we understand that the scale of this crime is much bigger because this number represents only a fraction of real cases because of underreporting, stigma, fear of retaliation, and the fact that the war continues, and it's a deterring factor for those survivors. According to Ukrainian law enforcement authorities, majority of CRSV cases were committed against women. Big number against men, and unfortunately, there's a number of cases of crimes committed against minors and underage persons. However, unfortunately, as I mentioned, the situation is much more serious, and we see it at the stage of reparations. In response to the war, Ukraine implemented a number of human rights protection mechanisms which support various survivor groups of Ukrainian population, and survivors of conflict-related sexual violence is one of them. And we can say that it's one of the advantages of what Ukraine is doing, and it's an unprecedented practice in a way where a country implements reparations and tries to remedy the violations alongside the military actions without waiting for the war to be actually over. So at the national level, Ukraine implemented an infrastructure which will deal with conflict-related sexual violence. A dedicated law was adopted in 2024, which formalizes the status of survivors of conflict-related sexual violence and implements the first attempt of reparations. At the institutional level, the following institutions are primarily responsible for dealing with survivors. Of course, it's the prosecution, which is being coordinated by the Office of the Prosecutor General in Ukraine. Within the office, a dedicated coordination center for victims and witnesses support was established, and it's one of the best practices because it helps law enforcement authorities, which are very commonly distrusted, which are not necessarily sensitive to in every situation, so not very much sensitive to the crimes that were committed, to be more survivor-centered and client-centered. And this coordination center indeed improves the situation with investigation and supporting victims and witnesses in the process. And of course, the Ombudsman's Office of Ukraine. As part of this mechanism to address these group of crimes, the Ukrainian government, together with international partners, implemented a interim reparations scheme. The implementer of this, and it's a very interesting approach because not the state of Ukraine is responsible for paying this reparation, but a partner, Global Survivors Fund, which I'm sure you've heard of, which is very present in Ukraine. With the support of international donors, Global Survivors Fund issues interim reparations for victims of conflict-related sexual crimes. And when we look at the statistics of these interim reparations, they offer us a very interesting comparison with official statistics by law enforcement authorities. If you remember, 400 proceedings officially registered and initiated by the law enforcement authorities. Well, Global Survivors Fund tell us that more than 1,200 persons applied for interim reparations. A little bit over than 1,000 were recognized as eligible for such reparations, and around 700 have already received such interim reparations. And the amount of reparations is the same for everyone. It's 3,000 euros, and it primarily aimed at addressing the basic needs that people have. Sometimes it's psychological support, medical support, and other accommodation, resettlement, and other basic needs. Interestingly, that out of 1,200 people who applied for reparations, 70% are men, which shows us a very grave picture of underreporting among men about conflict-related sexual crimes. This interim reparation scheme is recognized as effective. However, because it was in the pilot stage, the pilot stage ended, and it was planned that the government of Ukraine will pick up the mechanism and will continue implementing it through the Ministry of Social Services. However, the process was paused, and we currently were waiting for the government of Ukraine to develop the necessary legislation and also to find funding to continue the reparation process. Another interesting fact is out of these 1,200 people who applied for reparations, only 9% were referred from law enforcement authorities, which again shows that people do not trust law enforcement authorities, do choose not to communicate or initiate criminal proceedings. And the ultimate reason, I think, is the same in every case, is distrust, mistrust in the system of justice, and lack of assurance that the justice will be served. When it comes to reparations, another thing to be mentioned is that Ukraine, together with the Council of Europe and other international partners, developed, because the question of reparations is more comprehensive and has a lot of and has to address a lot of crimes, not only conflict-related sexual violence. So in order to establish this effective, comprehensive mechanism that would be able to tackle all crimes, the government, together with international partners, primarily the Council of Europe, established the International Register of Damages, which currently is functioning. The register accepts submissions from persons who suffer from various harms, who are victims and survivors of various crimes, be it property damage or various crimes committed against their life or life of their family members, enforced disappearance, conflict-related sexual violence, and other crimes which we see in the context of the war. The next step is the establishment of the Compensation Commission, which has not been done. However, the government of Ukraine and the Council of Europe agreed on the establishment of the commission, which will actually process all these requests and will make decisions on granting reparations. The third, and which is the biggest missing element, is actually the funds for payment of compensation. Ukraine is currently advocating for a seizure of Russian assets in various jurisdictions. It's probably a topic of a webinar or a conference on its own. We advocate that such a seizure of sovereign assets of the Russian Federation is not only necessary, but also allowed under international law, because international law allows for countermeasures in cases where a member state breaches its obligations under international law. However, The Russian Federation is a big state, it's a nuclear power, and we see a lot of reluctance at various levels to actually seize Russian assets. However, we believe that this process will be successful, and Ukraine and the Compensation Commission will receive funds to be distributed among survivors of Russian crimes. I would like to mention access to justice a little bit because we see that access to justice is a big issue for conflict-related sexual violence survivors, however, also for other victims of Russian crimes. And it's a big issue at the national level because the number of crimes are in hundreds of thousands, and the national justice system is overwhelmed, be it national law enforcement authorities who have to investigate and process cases, or courts that have to review cases, or national defenders or defense attorneys and legal aid system who are a necessary part and parcel of the justice efforts. In view of this, we see major issues in access to justice among survivors, including survivors of CRSV. The significant underreporting is the biggest issue, particularly for crimes committed in detention or under occupation. However, we also see that not that the crimes are being committed in houses of people who were in occupation, for example, and in other environments. And it's very difficult to find survivors and make them to talk to non-governmental organizations or law enforcement. In addition, there are other systemic barriers, such as complex, bulky legal procedures at the national level. The national level system is not perfect. It needs to be improved in so many ways. Multiple institutions that survivors need to talk to. The Office of the Prosecutor General now established a separate unit dedicated to CRSV, and they implement a number of novelty practices which actually mitigate these risks. For example, recently they implemented an approach of a single person. So a single person communicates with survivors. It's not investigators and prosecutors and then forensic experts. It's one person, which helps survivors gain control over their life and communicate with the justice system. And lack of specialized legal assistance. The legal aid system, as I mentioned, is overwhelmed. That's why we, in particular, Ukrainian Bar, alongside other non-governmental organizations, provide free legal assistance to various persons who suffer from various crimes. These are main issues at the national level. Very briefly, I would also like to mention that we need to think about CRSV globally. CRSV can be recognized as war crimes, crimes against humanity, or genocide, depending on the context. But we believe that we need a better system to ensure accountability for this grave crime. We have good practices of other tribunals, for example, Sierra Leone Tribunal, Rwandan Tribunal as well, analyzed and made conclusions about conflict-related sexual violence. But we see it in case of Ukraine, and I also know in the context of the conflict in Palestine, it is an issue that remains unaddressed at the international level, and we need to improve international accountability mechanisms. I will stop about the CRSV here. Very briefly about corporate accountability. I will only say that corporate accountability remains one of the least developed areas in the context of the war. Ukrainian state, as well as European Union and the United States, address corporate accountability by sanctions. However, sanctions do not, in this context, at least do not represent full-fledged accountability, but only a temporary measure which may be lifted depending on the political situation. And this is what we see. We see in various jurisdictions attempts to initiate investigations under the principle of universal jurisdiction. And this is something that we actually support. However, we believe that the crimes in Ukraine are of such scale and severity that they concern the international humanity and international community as such. That's why we invite various jurisdictions to initiate investigations against gravest crimes committed in Ukraine. And the Office of the Prosecutor General confirms that they are ready to transfer proceedings, and they will not and they will support various jurisdictions in investigating accountability. We don't see much efforts at the international level to investigate corporations in their role in the war. France probably is the best example, and this novel jurisdiction that tries to develop this approach. There was a development in the case of Lafarge. I don't know if you studied this in your class before, but basically Lafarge Corporation was prosecuted in France for a finance and for its involvement in crimes in Syria and financing of terrorism. And Ukraine tries to follow this example of Lafarge and use this approach to initiate investigations against corporations for their role in Ukrainian war. A big development happened a few days ago with the publication of the Yale Humanitarian Research Lab report about deportation of Ukrainian children. This report is the first official proof that shows evidence that Russian corporations, oil and gas corporations, are complicit in deportation of Ukrainian children and their militarization, because they and their and other entities linked to Gazprom and Rosneft financed special camps and other measures aimed at militarization of Ukrainian children. So we hope that reports like this will facilitate accountability for corporations. And in this respect, the role of civil society is of utmost importance, because this report was generated not by a government entities, but by civil society professional communities, civil society organizations, and we believe that this is one of the priorities in the context of Ukrainian war. We want evidence collected, analyzed, accumulated, and then advocated in front of international accountability mechanisms to ensure that everyone who is complicit in international crimes, will be held accountable. I will stop here. I don't want to take any more of your time, but if you have any questions, I will be happy to answer them.
Thank you, Ina. And we definitely have a lot of questions. There's a lot of threads that we'll hope to follow up on. So we will come back to you. But now we're going to turn it over to Lena to hear the same kind of a profile or overview of your assessment of where things are at. And then we'll be sure to leave time at the end to sneak in a few questions before our time's up. So over to you, Lena.
Thank you. I'm going to share a presentation. Don't worry, I'm not going to go through the entire presentation, but I will stop at certain slides just to kind of give a general context. I think the situation in the occupied Palestinian territory is, because it's been so prolonged of an occupation, there's a lot to say, and I want to make sure that I put it in context for you while we then focus a little bit more on the points of gender-based kind of crimes and violence, as well as corporate accountability that arises from that. So just really quickly, I think you have to give me permission to share. Okay, so 1 second, apologies. All right, so let me go ahead and put this in slide mode. Can see it. Okay, so essentially, I think it's important to recognize a few pieces of information about the West Bank and Gaza, which are two separate land pieces that together make up the Palestinian territory. The West Bank has approximately 3.5 million Palestinians in an area of about 5,860 kilometers. And the Gaza Strip, who many of you now know a lot more about, has approximately 2.1 million people in 300 square kilometers. Both of these areas have been under effective Israeli control since 1967, which means that this triggers international humanitarian law obligations. It is a situation of occupation, which is one of the situations of war. So humanitarian law applies. We are now talking about 59 years of prolonged and what is now considered an illegal occupation, across which Israel has violated almost every single provision of protections under IHL in a systematic way. Additionally, I would just mention, obviously, this is where IHL stems from, the Hague Regulations, the Geneva Conventions, especially Geneva 4, which concerns the protection of civilian persons, customary international law, and international human rights law, which applies to the OPT, as was confirmed by 2004 advisory opinion of the ICJ on the legal consequences of the construction of the wall in occupied Palestinian territory. So I'm not going to go into the general principles, but I wanted to kind of put this particular slide up for you, because I think it's really important to see the scale of violations that we're talking about when we're talking about violations in the occupied Palestinian territory. First and foremost, as was recognized also by the most recent 2024 advisory opinion of the ICJ on the situation of the occupation in Palestine, Israel is violating the right to self-determination of Palestinians. And one of the core principles of IHL is that occupation in and of itself is a temporary situation, and it does not provide sovereignty to the occupying state. So as the occupying power, Israel does not have sovereign ability to rule the West Bank and Gaza the way that it wishes, and that includes both the people and the resources, land, water, minerals, etc. And in continuing its occupation for so long without taking the kind of precautions that are necessary by an occupying power to ensure that it's only administering the occupation, Israel was violating the right to self-determination of Palestinians, because it was taking over the sovereign powers of that is instilled in the Palestinian people in this Palestinian territory. So that is one of the first violations. And I would just mention, I don't know how much you've had in international law, but the right to self-determination is a peremptory norm, which means that it's jus cogens, or one that is non-derogable, and for which there are consequences for all states if they don't take action, or there's certain obligations on all states to kind of help the situation go back to what is acceptable. So the right to self-determination is one of these kinds of non-derogable rights. In addition, and I'll skip some of these, but I'll skip directly to some of the violations of international humanitarian law, many of which you've already probably heard about or know about. One of them is the idea of settlements. Now, settlements in and of themselves don't necessarily constitute a specific crime or violation of international humanitarian law, but they do, if you break it down, what settlements actually mean, they violate a number of different obligations, including the prohibition on extensive appropriation, destruction of property without military necessity, and particularly for civilian property, appropriation of water and minerals in a way that doesn't meet the specific standards under IHL, the forcible transfer of populations from their homes or from areas in which their homes are to other areas, or, for example, in the use of detention within proper Israel, so removing them from the occupied territory and transferring them forcibly into other territories, and moving their own civilians into occupied Palestinian territories. Together, all of these are serious violations of IHL, all of which are being done as a policy by the Israeli government. Additionally, there are countless violations of fundamental human rights, and all of the civil and political rights that you can think about, some of the cultural rights, the economic rights, the social rights, violations on freedom of movement, freedom of assembly, freedom of expression. So one of the first things that the Israelis did when they took over in 1967 was they passed a number of military orders, and military rule applies to Palestinians in the occupied Palestinian territory. So it's not civilian law, it's military order. And within those, there are orders that are passed by the general that rules over the West Bank and Gaza, an Israeli general, that said that, for example, having more than 5 people without a special permit in any place could constitute a violation, and there's imprisonment that could come along with that. So all of these kinds of fundamental rights, civil and political rights, are arbitrarily denied to Palestinians, and they have been over the past 59 years or so. Additionally, there's a level of unlawful detention that is really unprecedented in most places, arbitrary imprisonment. The military justice system, under which Palestinians are brought forth for, whether it is for political crimes or actual just run of the regular crimes, they are brought before military systems, and the military systems has a 99.4% conviction rate for Palestinians. It does not have very many due process limitations, and because of that, many human rights organizations have already ruled that the military system and the justice system that is applied to Palestinians is, in and of itself, completely unacceptable and doesn't provide the necessary due process, etc. That's not to mention, that children are tried within this, women, etc. And of course, as you've seen more likely in the past few years, although this has been a kind of marked part of the occupation, Israel uses widespread and sanctioned torture against Palestinians, whether it's in detention or whether it's in military operations. And this has a disproportionate effect against women and children in particular, but it does it across the board with all Palestinians. And this brings me to the area that a lot of people contest or have a lot of issues with, but all of these kinds of violations over a prolonged period of time with systematic and widespread uses, and that have basically come to the level of becoming policy by the Israeli government, have given rise to different organizations and human rights groups and justice mechanisms to say that we have additional violations that come up to the peremptory level, which include violation and prohibition of apartheid, which I've put up the definition of apartheid for you in very simple terms: the institutionalized regime of systematic oppression and domination by one racial group over another, committed with intent to maintain that regime of domination. That has been decided by Palestinian human rights organizations, Israeli human rights organizations, international human rights organizations, as well as a number of UN mechanisms, and as well as special rapporteurs who've said that the situation in the occupied Palestinian territory has come up to the point where it has now crossed the threshold, as Human Rights Watch says, into the situation of apartheid, which is one of these jus cogens. The prohibition on it is again jus cogens. Additionally, like I mentioned, the 2024 ICJ advisory opinion ruled on the illegality of the occupation, looking at settlements and the annexation that Israel has taken over in many areas, whether it's de jure in East Jerusalem or de facto in areas C and B in the West Bank. The ICJ declared that the continued presence is illegal, and that there's an obligation of Israel to withdraw its military forces and end its occupation and end all of the measures that would bring it to that level. And then it also said that there's a right to full reparations for the damages that have been caused, including restitution, on a collective level and on individual levels, compensation, all other kinds of reparations that come as part of that regime. And finally, I mean, unfortunately, as you've, I'm sure, have seen, in the past 3 years, we have seen a situation of what we believe to amount to the crime of genocide being committed against Palestinians in Gaza, but also extending to other areas. And the idea, I just want to give you the definition of what the crime of genocide means. It's not just a political term, it's an actual international crime that is defined. And this is how it's defined in the Genocide Convention. It's committing any of the following acts below with the intent to destroy in whole or in part a national, ethnic, racial, or religious group as such. Killing members of the group, causing serious bodily harm or mental harm, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent births within the group, and forcibly transferring children of the group to another group. I think that arguably at least 3, if not 4 of these acts have been committed over the past 3 years that have led many international experts to rule or to say that Israel is committing a genocide in Gaza and continues to do so as well. And here I would mention that all of these crimes, and I'm just putting these up now so you can see them. There are some of the statistics that Human Rights Watch has had about the Gaza harm and destruction. We have approximately, and now I think since this has been published, we've reached over 70,000 Palestinians, name by name, killed, and probably more, because there are many that are under the rubble or that have been disappeared that we don't know where they're at. In addition, of those, and this is where we talk about how does this impact women and children. Of these, approximately 70%, between 67 to 70% are women and children. And because of that, and because of the way in which the acts were conducted, the Special Rapporteur on the violence against women at the UN Special Rapporteur, in July of 2025, actually released a report in which she cited that she believes that this is a femicide, that this is a genocide, particularly targeting as well women and children, and because it met that level. And in doing so, you know, that this is kind of a new word in general in terms of the way in which these kinds of action takes place. One of the ways in which you can say that this is a genocide and not simply just direct hostilities or an act of war is by looking at the way in which the principles of IHL, the 3 or 4 major principles of IHL, proportionality, distinction between combatants and civilians, the precautions, to take special precautions to ensure that civilians are not unduly harmed in order to meet a military necessity. If you take those standards and you apply them to what took place in Gaza from the very beginning of the war that started in October, you see that there is a complete disregard of any kind of laws of war there, and that there was a clear targeting of whether it's women and children, whether it's all of the civilian infrastructure, protected infrastructure, hospitals, aid workers, journalists, medics. Each of those categories that I just mentioned have specific protections that are part and parcel of the laws of war and are essential to the way in which modern warfare has been conducted since, I would say, since World War I, but also since World War II, even more so, to the point that many of these rules have become customary international law and not simply treaty-based. In the Geneva Conventions, there are mechanisms of looking at how you then enforce accountability for these kinds of violations. And I just wanted to also bring up the West Bank, because I think, we're so focused on what's happening in Gaza because of the scale, but that's not to say that this is just 2025. So just imagine that just in 2025 in the West Bank, which we don't consider to be an active direct hostilities, it's just a situation of occupation. We had 182 Palestinians who were killed during that time. And since October, 969 Palestinians were killed in the West Bank alone in those 3 years. Additionally, I think, there are massive displacements that are taking place across the West Bank, whether it's from refugee camps in major cities like Jenin, Tulkarem, and Nablus, but also across areas C, which is basically the breadbasket area of the Palestinian territory in the West Bank, where Bedouin communities, herder communities are being pushed out of their homes and their areas by settler violence, by military violence, and by different systematic means of pushing Palestinians out of as much land as possible so that settlements and the settlers and the Israeli state can control it for their own purposes, many of which are actually financially based, and that's where I'll get to. So what does this do for Palestinians? Sorry, I think that half of my screen is not showing, but essentially, women and children are always the hardest hit when it comes to any kind of violations that you see. And over time, they are the most disadvantaged, and they're the ones who face the most pressure, because they are coming into a system that is basically stacked against them at all different levels, whether it's within the home, within the community, as well as within the larger sphere. When you have movement restrictions, it's more likely that women and girls are going to be the ones that are not going to be allowed to go from one city to the next, whether it's for work or for education or for health purposes, because of fear of the kinds of harassment they face at checkpoints, the kinds of harassment that they may face if they get detained in any way. And we know that there's definitely a level of harassment and sexual violence that has been used against women and girls, and particularly in those communities that are targeted for forced displacement in the West Bank, but as we saw across Gaza as well. I know that we're very limited on time, but I do want to point out that there are many different mechanisms that call for gender-sensitive reparations for violence within conflict. And you see this whether it's under the CEDA or whether under the UN Security Council Resolution 1325. They call specifically for women to be involved in any peace talks and to be involved in any structured governmental kind of policy following conflict, and to be very much involved and in direct part of the reparations schemes that come out, because they want to ensure that they get what they need. I think as much as I can say. So what does this mean in the sense of accountability? And I think that there are a lot of different, theoretically, there's a lot of different ways in which you can get accountability. And obviously under the international scheme of things, there are, like I mentioned a couple of times, there are kind of obligations for use cogents. And use cogents, that, like I said, are peremptory norms. Those are the norms that most states agree together, whether through behavior or through language or through treaties, that they believe are the essential rules that nobody can violate. And if anyone violates, any state violates it, all states must act in some fashion to prevent it, that they have a responsibility to prevent the continuation of that violation. And what do these look like? So according to the ILC, the way that they kind of codified these obligations, it's the obligation to not recognize. So states cannot recognize through action unlawful acts such as annexation of territory or settlements. And what does that mean? That means that you cannot continue to behave as though those actions, the annexation, so for example, the annexation of East Jerusalem, which has been widely recognized to be illegal since it took place. States cannot behave as though Jerusalem is part of Israel. And it cannot recognize that to be okay, because if it does, then it's violating its own obligation, not just is Israel violating the law, but then it is that third state is violating the law in recognition for by example, moving your embassy to Jerusalem as the capital of Israel. In doing that, you're recognizing a situation that is unlawful in a way that violates your own obligations. In addition, non-assistance. So states should not be providing assistance or aid in maintaining unlawful situations. So what does that look like? That's like through trade, through arms sales, providing diplomatic cover, whether it's at the UN Security Council or in direct relationships, or even, the EU treaty of trade treaties with the state in ensuring that settlements and other, fruits of those violations are not part and parcel of the situation of assistance that it may provide. And finally, there is a rising kind of belief that there is a positive duty to act. So all states must cooperate to end the serious breaches of peremptory norms. What does that look like? What can it look like? It can look like sanctions. It can look like diplomatic pressure or support for accountability mechanisms, like we saw with South African situation of apartheid when there was sanctions against it, etc. And then, okay, so what does that mean for corporations? So more and more in the past 20 to 30 years, corporations have become international actors. It's not just states. So corporations actually are moving and working across borders and carrying out activities that in the past we only gave to states, and they are domiciled in more than one place. So under this kind of approach, corporations have responsibilities and have to ensure that they are not acting within or as part of international violations of human rights or humanitarian law. And we saw a little bit of development towards this within the UN guidelines for business and human rights and other kinds of rising new approaches to holding corporations accountable. But still, the strongest form of holding corporations accountable is within nation state rules and laws, ensuring that companies that are domiciled in a particular state follow the rules of that state, including not violating international human rights or humanitarian law. I just want to point to you another report by Special Rapporteur. This time it's the Special Rapporteur of the UN Special Rapporteur on the situation of human rights in the occupied Palestinian territory. She released a report in July of 2025, specifically on corporate accountability. It's entitled "From Economy of Occupation to an Economy of Apartheid," and there she highlighted the idea that the corporate involvement in the occupation in Palestine and in the genocide as well in Gaza in particular has been systematic, it's been profitable, it's been indispensable to the continuation of the occupation and the destruction of Gaza. It involves weapons, it involves technology companies, it involves construction companies, energy companies, agro-businesses, logistics, tourism, finance, and then academia, and each at different levels of complicity. Some have reached the level where their actions bring themselves to the point where they can be actually accountable for participation. And I think the way that she talked about it in her own report was actually a direct complicity. So like a criminal enterprise, I believe. And that is something that I think that companies need to take into account. And the way that we make them take it into account is by ensuring that they are brought to account in state courts, in international courts. You know, I can guarantee you, if one company is brought before the ICC because the prosecutor decided that it was participating in the pillaging of Palestinian resources in the West Bank, all other companies that operate there would take a quick step back and say, whoa, wait, there's a level here of accountability that I need to take into account, because that's what runs rule of law at the end of the day. It's making sure that there's being held to account. So again, I'm just reminding you of what I've spoken about already, is what does accountability look like? Diplomatic interventions, sanctions, arms embargoes, trade and financial restrictions, corporate withdrawal, accountability for executives. You know, even though the ICC, for example, doesn't recognize a corporation as an individual in the legal sense, executives that run those corporations certainly could still hold accountability. And then, of course, reparations. And one way in which this reparations could take place is not simply by the states themselves, but even by the corporations and through an apartheid wealth tax, as the special rapporteur kind of mentioned and explained in that July 2025 report that she put out. Finally,
I'm going to have to jump in. We're going to have to just stay with your slides. I'm sorry, we're coming up at the end of our period, and so we're going to, students are going to have to break to go to their other class.
Sorry, I'm done. So I just wanted to say thank you so much for this. And I know it's a lot, but I think that there are a lot of things that one can do. And I hope that this provides you kind of an overview of what I just presented.
No, it was very rich, and I do hope that we can get your slides and share them with us. And I hope that the conversation can continue. We're really grateful for you both taking time out of your work and your evenings to connect with us, and we'd love to continue to partner and have this exchange. I know we're saying goodbye to you, but the conversations here at Minnesota are going to continue, and this gives us these great building blocks of questions that everybody is sitting here with that we want to follow up on. And then now in our continued conversations with experts, we're going to be able to continue to process today. But we were short on time, and I hope that everyone here in the room will join me in thanking Luna and Ina for joining us and for the really good presentation. Thank you both so much. All right, and we'll be in touch. For everyone that's here in the room, we're going to reconvene at 9:30 for Chris Roberts, and there is coffee on the outside of the room. All right. Thanks, everyone. Thanks to Randy. And thank you so much, Ina and Lena. Really grateful for your
Thank you so much to
today.
you, and good
Thank
luck in
you.
your discussions. Bye.
Thank you.
Bye-bye.
To be
Have a good
continued.
morning. A heavy morning. Goodbye.
Thanks so much.